Well, hello there, and welcome to the Employment Law Show once again. I'm John Scholes. Joining me momentarily on the other half of the screen will be Lior Samfiru, so stand by for that. He's here again this week. We got all kinds of stuff to share on this half hour, educate you as well. Our main topic in just a bit, understanding severance packages. Sounds like it's back to basics, but that's because we get new viewers every week, so we want to go back and reiterate some of the things, the important things you'll learn with employment law, and this one, severance packages, is a huge one for sure. Always a reminder, you can reach out to Lior and his team anytime on your own time. Phone number 1-855-821-5900. help@employmentlawyer.ca. And there's also a website called pocketemploymentlawyer.ca. We'll show you how that works in just a bit. Lots to get through. And then at the end of the show, we'll get to our rapid fire, which is where, we kind of put Lior in the hot seat really quick to answer some questions. But again, it's all for education, all for your benefit. So we'll get to all of that. But we always start, Lior, with the week that was, the case of the day. Pal, oh, there he is. How are you? What's going on this week? What do you got for me?
Hey, Johnny, doing great. Excited to be here, as always, to talk about employment law and trying to demystify this topic. We all have jobs. We all have rights and the job. Unfortunately, too many of us don't know what those rights are, don't know what the law can do for us. Well, you don't have to worry about that, because on this show, we'll tell you what those rights are. We'll tell you what you need to know if your boss is not doing something properly, if you're working for a company that's not treating you well, if you lost your job, if you've been discriminated against, if you're not being paid what you're supposed to be paid. You get the idea. This is all about workplace rights. I spend all my time, even when I'm not here on TV, answering questions, talking to people. So beyond just this 30-minute show, you can always reach me in the office to have a private discussion. That phone number and email address, John gave it already. We'll give it to you many times throughout the show. So don't be bashful to make that question, ask that question, make that contact, because that's the only way you're going to have your rights enforced. And let me give you an example of a situation that came across my desk over the past number of days. I spoke with a gentleman who had accepted a very senior position with an employer, a management position, a well-paying position. He had been doing work in that industry for years, and signed a comprehensive employment agreement when he started working. Unfortunately, for reasons that are not even that clear, 2 months or just 2.5 months into that, his employer says, you know what, I don't think you're the right fit. Things are not working out well for us. And since you're in our probationary period, it's been less than 3 months, we're going to let you go. We're going to be nice to you, though. We're going to offer you 2 weeks pay. You've only worked for 2.5 months. And goodbye, we wish you all the best. So this person, of course, very upset, frustrated, contacts me. So I take a look at his employment agreement. Even though he signed an employment agreement, it did not contain a probationary clause. It did not say anything on probation. So what does that mean? It means he wasn't on probation. He was not on probation even in the first 3 months of employment. Because he's not on probation, he's owed full severance. And guess what? Even after 2.5 months of employment, he was owed between 4 to 5 months of severance. Yes, the amount of severance was more than the length of employment. So there's a few things here to understand. Number one, probation is not automatic. Just because you started a new job does not mean you're automatically on probation. The only time you're actually on probation is if you sign an employment agreement that says that for the first 3 months, you're on probation and you can be let go for with no compensation. So if you sign something like that, sure, you're on probation. If you did not sign something like that, you're not on probation. It's not automatic. The other thing, of course, as we saw here, short service. This guy only had 2.5 months. Does not mean no severance or little severance. Short service employees still have severance that's calculated in months, not days, not weeks. This guy, 4 months severance after 2.5 months of employment. So if you lose your job, doesn't matter, long service, short service, you call me. If your employer says you're on probation, they're not going to pay you anything when they let you go, you call me, do the right thing.
Does it matter the length, Lior? For instance, if an employer says, I'm going to get smart, instead of 3 months, I'm going to put you on a 6-month probation. How does that affect, or does it affect anything? What do you think?
The reality is the only time that you can be let go without any compensation is the first 3 months of employment. And only, of course, if the employment agreement says so. So as a practical matter, you can't really be on probation for longer than 3 months, because after that, you have to get severance in any event. So no, for all intents and purposes, probation can only be the first 3 months of employment.
Let me ask you one more question, though. If you're pulled away from secure employment, you're induced, as we say, in legal terms, to come to another company, and they give you an employment agreement and it's got a probationary period, you should not sign that if they've pulled you away from a secure job, right?
It's always like we've talked about these things before, John. You're absolutely right. No, if you're leaving a secure job to start a new position, they came to you, they recruited you, they headhunted you, and you're going to join them. Don't agree to a probationary period. Why would you leave a secure job to be on probation? Don't agree to a term that limits your future severance. Why would you do that? You have negotiating power, and because you've been recruited, you may be owed enhanced severance down the road as long as you don't sign something that gives away your rights.
Quick reminder, by the way, radio shows, we do them pretty much across the country, have for years and years. They're really informative. Most of them are an hour long, half hour here in the GTA in Toronto. But you can always join us at whatever respective station it's at. We encourage you to call in, ask your questions, get educated. It's always a good time to have a bit of a round table with our callers. Lior, we want to get to a couple phone calls, maybe 3 on the show again this week. First phone call, let's listen up and we'll talk about it. It's coming right now.
Technically, I'm self-employed, so I do IT, and I've been working with the same company for the last 14 years. Only one client. I invoice them every 2 weeks, and then they recently got bought out about 3 months ago. The new owner is now want me to kind of reduce my hours, and then I turn 65, and they want me to kind of leave by then. So I don't know if I have any course of action.
Wow, there's a few things to unpack here, John. So the first thing is, of course, he's not self-employed. Of course, he's not a contractor. He's an employee. He's been working for this company for 14 years. Come on, how do you become more of an employee than that? This is a common situation where someone has been misclassified. Happens all the time when someone is called a contractor or self-employed, but they look like an employee and they act like an employee. Therefore, the law says they are employees and they have the rights of an employee. Now, because this guy is an employee, his employer cannot just reduce his hours. That would be a constructive dismissal, meaning he's owed severance. So what does this mean? If his employer goes ahead and reduces his hours, he can say, no, I'm not accepting that. You now must pay me severance. The last question, of course, how much severance? We're going to go to the severance calculator to find out. You can use it yourself at any time at pocketemploymentlawyer.ca, free and anonymous. Let's use that in this situation and see what we get. So we know that this person has been there for 14 years. He's 64 years of age, working in an IT job. He's an employee. Therefore, you see on the screen there, he's owed 16 to 20 months of severance. Yes, he's an employee. That's what he's owed. You can find out yourself how much you're owed at pocketemploymentlawyer.ca.
And I especially love the resignation piece at the end. When you get to this age, you can resign. Have a good day. Like they did everything wrong here, practically, right?
They did. You cannot be forced to resign or even told to resign. There's no such thing as mandatory retirement. We got rid of that many, many years ago. And just the suggestion that you should resign in itself could be a human rights violation.
Again, employmentlawyer.ca to find a radio station in your town where you can catch our show. Phone call number 2 is coming up right now. Lior, listen up.
An employment situation actually for my wife. So she's been on a renewing contract, working part-time, approximately about 15 to 16 hours a week. She just got a letter a couple of weeks ago saying that the contract, which was going to end, was not going to be renewed, and that was it. And so we were just wondering about if she's entitled to severance.
How many of these contracts has she had?
She would be on her third one.
That's the threshold,
So
right?
Yeah, this is exactly what we've been talking about in the past. When you have contracts that you sign, they get extended. You sign another one, they get extended. Well, at some point, the law says, forget about the contract. You are now a regular employee, an indefinite employee. Now, usually kind of the 3 contract is the threshold, so she's right there. So what does that mean? That means that she may be able to say, no, even though I've signed a contract that's expiring next week, I am now an indefinite employee given the history with the company. Therefore, if you're going to let me go now, fine, but you have to pay me severance. So that's the key, and that severance could be significant. I've talked to many people over the years that every year they sign a new contract and again, and they think they're really still on contract. You're not. At some point, the law says, forget about it. You are an indefinite employee. And if you're going to be let go, full severance has to be paid. So keep that in mind if you sign these contracts all the time.
Okay, Lior, we have our third phone call lined up. We'll do it on the other side of the break. And then, as mentioned, we get into our main topic, understanding severance packages. Key information, so stick around for that as we continue. But always have that number handy, 1-855-821-5900, help@employmentlawyer.ca. More Employment Law Show is on the way. On the other side, stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Thanks for hanging around. Employment Law Show. We got lots more to go. I mentioned the phone calls that come in threes. Those generally come from our radio show. Tune in. Find a station near you that carries the show. Lior and I have been doing this for about 13 years, I think, at least. Lior, it's been a long time, pal. And you can do so employmentlawyer.ca. And then always call Lior in your own time. You want more information. The chat will cost you nothing. Just pick up a phone. 1-855-821-5900. Finally, email help@employmentlawyer.ca. Okay, before our main topic, Lior, phone call number 3 is coming right now. Listen up.
I've been working at a company for over 40 years. Been working from home for about 20. The last 9 years, I've had a job where I haven't had to go in the office at all. I never had to sign anything before, and now they are asking me to sign an employment agreement for working at home, which states that they can terminate their arrangement at any time at their discretion, and that it wouldn't constitute a constructive dismissal. I'm just wondering if I have to sign this.
Mm-hmm.
Absolutely not. Not only does she not have to sign it, she should not sign it. So she's now working remotely, meaning her employer doesn't have a right to change the terms of employment by having her come in. But if she signs that employment agreement, all of a sudden now they will gain that right. So if she signs it and the next day they say, now you have to come in 5 days a week, she won't be able to do anything about it. And if she doesn't come in, that's a resignation. She should not sign that. And potentially there could be other problematic things in that employment agreement beyond just this remote work issue. So if she's working remotely now, she's been doing it for many years, if her employer wants to change it, here's what happens. Let's say her employer says, moving forward, you have to come into the office instead of working remotely. She doesn't want to, so she says, no, I'm not doing that. What happens then? Well, one of two things will happen. Either her employer is going to back off and say, okay, fine, we changed our mind, you can stay remotely. That's option one. Or her employer may say, fine, then we're going to let you go. Now, they're allowed to let her go, but they're going to have to pay her severance. She's been there for many, many years. That's going to be about 2 years of severance that they owe her. So it's not a resignation if she refuses. It's not a termination for cause. She's owed severance. Same with you at home. If you've been working remotely for years, if your employer wants to change that, then you say no. You may be owed severance if you lose your job. It's not a resignation. If that's your situation, before you say yes or no to your company, and certainly before you sign anything, give me a call.
Can she, Lior, I mean, it's been a long time, 40 years, congrats on such a lengthy employment in one workplace. If she wanted to say maybe change the scenery, take it out for a spin, try it, does she have to commit to it right away, or can she say, you know, a couple weeks, if I don't like it, we're going back to the 40-year arrangement? Can she do that?
Well, what she should not do is sign that document. But without signing the document, she can say to her employer, okay, employer, let's try this for the next few weeks, see how I manage with coming into the office, and then I'll let you know where I stand. She can do that and try it out. But if she signs that piece of paper, that piece of paper would give her employer the right to do whatever it wants. Bad idea. By the way, always, always important. If you're asked to sign a new employment agreement, be very concerned. It's not a good thing. It's not a trivial thing. It's a problematic issue. It could be giving away rights that you otherwise have. So what do? You call me, you have me review it, you do it right.
Let's get to our main topic for the show, Lior. That is understanding severance packages. Kind of back to basics thing, but it's such a huge topic. People have to understand. I mean, that last phone call is a perfect example. Question now, what is a severance package and why do employers offer them? Basic, but go for it.
So the first thing I want you to understand that a severance package is not something your employer is offering you because they're nice guys. They're not offering you that because, we just want to help you out. No, it's a legal obligation to provide severance. It doesn't matter what the employer wants to do. It doesn't matter if they like to do it or if they think it's fair. None of that matters. The law requires you to get severance if you lose your job. Now, severance is an amount of compensation that's intended to carry you, to support you until you find another job. So it's not a punishment to the company for letting you go. The company doesn't have to pay severance because they're bad and they get punished. Severance is there to help you, the employee, while you don't have other work, so you can still pay your bills, so you can still support your family while you're looking for another job. That's what the law requires the company to do, and that's why severance packages exist, John.
Okay, question 2. What is the difference between the employer's offer and what you're actually owed? I guess kind of the $1 million, or at least the tens of thousands of dollars question generally. What do you think?
So every person that's let go, almost every person, is going to look at a termination letter, the severance offer. Here's the thing. Almost all of those people, the offer that they received is inadequate. I can say this because I've been doing this for 22 years, and I've literally looked at thousands and thousands of severance packages. 90% of them, 90% of those severance offers, severance packages, are not adequate. They're less than what you're actually owed. They're less than what the law says you should have. So if you just lost your job and you're staring at that termination letter, I can tell you without even looking at it that there's about a 90% chance that you are owed more, and usually much more. Now, why does that happen? Well, there's several reasons. The company itself may not know what they have to pay you. That happens all the time, big and small companies. But the company actually may know what they have to pay you, but they hope you don't. They hope they can kind of get away with paying you less than what they owe you. And you know what? Unfortunately, in many cases, they do, because the employee doesn't know. They're offered pennies on the dollar, 20, 30 cents on the dollar. The employee doesn't know, so he accepts it. Don't let that happen to you. There's a big difference almost always between what you've been offered and what you're owed. And once you sign that, you cannot change your mind. You cannot go back. So never do that without speaking to me first.
Okay, Lior, so you've got the offer, then you've got what you're actually owed. It can be a very large delta, as you'd like to say. So what influences the difference there?
Well, the main kind of factors really that go into that are your age, your position, the length of your employment, but there's other factors as well. Anything that could impact your ability to find another job is a legitimate factor that must be considered in calculating your severance. For example, if you have a medical condition, well, that may make it harder to find another job. If you work in an industry where there's just not a lot of jobs, well, that's going to take you longer to find a job, meaning you get more severance. If you are looking for a job in a bad economy, again, it's probably going to be harder to find another job. So guess what? Bad economy means more severance. And there's many other factors like that. So it's not a week per year. It's not 2 weeks per year. For the vast majority of people, it's a lot more. I gave you at the beginning of the show an example of someone that had only worked for 2.5 months and was owed 4 months severance. There's nothing unique about that. It happens all the time, which is why I say if you have a severance package in front of you, you lost your job, you call me. Chances are you're owed much, much more.
Okay, Lior, along those lines, so I mean, many of our viewers, including myself, probably you when you were younger, we've all been, come in the morning, you get taken down to that room, it's got the frosted glass, there's 3 people sitting there, they slide you the offer. Should you be signing that package during that meeting? Because they're going to want you to. It's a pressure situation, right?
Well, no. Not only should you not sign this at the meeting, you shouldn't sign this at all, certainly not without getting legal advice. terrible idea to try to sign this in the meeting. You're obviously going to be in a difficult mental state. You just lost your job. You didn't expect it. You're worried. You're nervous. To try to sign something and make a decision on the spot, terrible. A half-decent employer won't even ask you. In fact, will tell you, don't sign this on the spot. Take it home. Think about it before you sign. But I'm going to go a step further. Severance offer often is going to have a deadline. Don't worry about that deadline. Okay, your legal rights don't expire Tuesday at 5 o'clock. Your legal rights don't expire for 2 years. And why would you accept something that's less than what you're owed? So don't worry about that deadline. Certainly don't sign anything on the spot. If you want to know what you're owed, you can use the severance calculator. We've already told you about that. You can find it at pocketemploymentlawyer.ca. You can give me a call. You don't like me, call another employment lawyer, but never, ever accept that severance package without getting legal advice.
So, I mean, it's basically going to come down to negotiation when it's all said and done between what they're offering and what you're owed. As far as non-unionized employees are concerned, Lior, how do you navigate that, the negotiation, and improving it, right?
So it's not a complicated process. Once we establish that, yes, you're owed more, we're going to write to the company. We're going to outline exactly why you're owed more and what makes sense. The company is going to respond. There's going to be a little bit of negotiation, and we get this resolved. Now, the key here is to work with someone that knows what he or she is doing. If you try to do this on your own, it's not going to work. You're not going to know what to ask for. The company's not going to take you seriously. They may not even get legal advice if you're going on your own to try to do it. So you have to allow us to do what we do. Generally, just our name on the letterhead is going to get the deal done. So do the right thing, do the smart thing when it comes to your severance. Let us do our job and negotiate proper severance for you.
Okay, Lior, and for you as well, let's take a short break, get back into it. More questions on the other side, and we'll get to our employment law rapid fire near the end of the show. In the meantime, always write the number down. Always have it with you to contact Lior and his team, 1-855-821-5900, help@employmentlawyer.ca. Lots more of the show coming up. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Employment Law Show. Lior Samfiru right there. John Scholes, always your host on the show for the half hour. You want to reach out to Lior anytime on your own time, 1-855-821-5900, help@employmentlawyer.ca or simply employmentlawyer.ca. That'll give you links and a place, a resource to find our long-running radio show. There's also another place where you can ask questions, terminationquestions.com. It's free. It's anonymous. Again, terminationquestions.com. For this week, Lior, here is our question. I was given a proposal, either accept a temporary layoff or take severance and leave. I haven't signed anything yet as I wanted some clarity. I've been with the company for just over 5 years, earning a salary of $85K per year. My title is Business Development Manager. I'm 41 years old. What should I be offered?
So the first thing I have to note that it sounds like this employer is actually doing things right. An employee does not have to accept a temporary layoff. So this employer is saying, okay, we know you don't have to accept it, so we're going to give you another option of taking a severance package. Remember, by the way, if your employer puts you on a temporary layoff, you can accept it and wait at home to be called back, or you can choose to treat that as a termination and get your full severance. So we know that this person has the option of getting severance, but of course, we want to make sure that the proper severance amount is paid, not just any amount. That employer may know that they have to pay severance, but they just may not just realize how much severance. So how do we know? How can you find out? Easy. we're going to use this fact scenario and plug it into our severance calculator tool. We're going to go back to pocketemploymentlawyer.ca, click on the severance calculator, plug in the information, and let's see what that gives us. So looking at it, we see this person is a middle manager, been there for 5 years at the age of 41. We don't know yet what the company is offering for severance, but what we do know is this person is owed 6 to 9 months of severance. That's the right amount. Anything less will be improper. Same with you at home. You want to know how much severance you're owed in a temporary layoff situation, in a regular termination situation, not a problem. Go to pocketemploymentlawyer.ca. It's free and anonymous, so check it out.
Okay, another resource I want to mention, Lior, for our viewers and our listeners of the radio show is all the live streaming you do and the other colleagues at the firm. You can go to Facebook, YouTube, LinkedIn to do so at stlawyers.ca, at stlawyers.ca. And from the live stream, here's a question for this week. It says, I work in a manufacturing plant and a new company is taking over. The plant has decided not to retain any employees from the previous owner. They've stated that we aren't owed any severance pay. What are our rights here?
Well, that's obviously nonsense. Remember, it's not complicated. If you want to know when severance is owed, it's simple. If you lost your job, you are owed severance. It's as simple as that. So if as a result of a sale of a business, you are losing your job, you're not going to be working anymore, of course you're owed severance. And in a sale of a business situation, usually it's the seller that owes you that severance. The seller sells the company to a buyer. Buyer doesn't take you on, they don't want you, okay, they can do that, but then the company selling the business must pay you severance, and that severance can be as much as 24 months. There's no way in a sale of a business to lose your job and not get severance. Simply not possible.
Does the buyer ever have to pay that severance quickly?
So if you work for the buyer, if the buyer takes you on and at some point later lets you go, then the buyer inherits your service. And of course, they're going to have to pay your severance package when they let you go. But if you never worked for the buyer, they don't have to pay you. It's the seller that would have to pay in that situation.
Got it. It is time for Employment Law Rapid Fire. Let's get into that right now. Lior, strap in, pal. Okay, number one question. First question, can your employer put you on a working notice months before your termination date?
Yes, so an employer can give advance notice of termination. We call this working notice, and that amount of notice counts towards your severance. Keep in mind, in most cases, you're still going to be owed additional severance at the end of that notice.
Rapid fire number two, is your employer allowed to ask for private medical information?
Absolutely not. Your employer doesn't have a right to know or to ask what your condition is, what treatment or medication you're taking. The only thing they're allowed to know is can you work, can you not work, and what accommodation you're owed. That's it.
Number three, for rapid fire this week, Lior, can you choose to work for a competitor after resigning?
So in most cases, you can. You want to be careful if you signed a non-compete. That may impose obligations on you. So if you sign a non-compete, don't ignore it. Let's talk about it first.
Number four, can your employer shift your title and duties to a coworker?
Well, if they do, that could be a constructive dismissal. If they take your job, your responsibility, make significant changes, you may be able to treat that as a termination and get severance.
4 for 4, pal. Let's knock it home with the fifth one. Finally, can your employer revoke your approved vacation? That's nasty.
Well, they can only do that if you haven't spent money in reliance on the approval. Okay, so if you've spent money, you've made plans, they can't just take that away. In other situations, they may be able to do that.
And we are done. You got it all in, pal. We're going to leave you for the week. I'll give you some contact information as we fly out of here. The phone number, 1-855-821-5900, help@employmentlawyer.ca, and that website, pocketemploymentlawyer.ca. We'll catch you next time. Thanks for tuning in.
People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.